Senior Citizen Act, we have discussed that it is a summary procedure before the tribunal for granting maintenance to the senior citizens. Recently, an interesting fact came before the Honorable Apex Court, wherein the Act of 2007, Senior Citizen Act, was used for eviction. The question before the Supreme Court was that whether the a detailed procedure available in other acts can be skipped and the provision of Senior Citizen Act can be availed for eviction of the occupant by the senior citizens. The case is S. Vanitha, S-V-A-N-I-T-H-A versus Deputy Commissioner, decided by 3 judges of Honorable Apex Court. In this case, the appellant is the daughter-in-law, the Bahu. Case before the lower court and before the Deputy Commissioner was that the senior citizens moved an application for eviction of daughter-in-law, which application was allowed on the plea that the Senior Citizen Act 2007 has a deeming provision of eviction in favor of the senior citizens. The daughter-in-law, that is appellant, came before the Honorable Apex Court asserting that there is a family dispute and she has to avail a right under Domestic Violence Act also. She is living in a shared premises which is protected by the DV Act. She has to claim the benefit of the provision of DV Act also. That is, she has a right to remain in the shared premises, shared household. So there is a conflict of interest between the DV Act as well as the Senior Citizens Act. The Honorable Apex Court considered both the aspect and observed that both the acts are for welfare. They are special act. DV Act is for the woman and who is suffering in the hands of her in-laws. This is one aspect, her in-laws. And Senior Citizen Act is also for senior citizens who is suffering in the hands of her children. That is, the children are not taking care of, looking after him. So in this case, what should be the approach? Whether the summary procedure of Senior Citizens Act can be used for eviction of in such cases where a daughter-in-law has occupied the premises. No, the Apex Court came to the conclusion that though the situation in this case was entirely different. Senior Citizen Act and the summary procedure provided in there cannot be utilized for eviction of the daughter-in-law in this particular case, since she has a protected right under Domestic Violence Act of occupying the premises, being a shared household. So she has a right to remain in there. At the same time, the parents can seek a remedy under Section 10 of the Senior Citizens for alteration of the maintenance, etc. So in such case, the one thing is clear that Senior Citizen Act cannot be used for eviction of the children. Thank you.